Okay, friends, welcome to this special session. Why it is so special? Because we had our law optional papers yesterday on 24th. And what's your reaction to both the papers? Let's take paper 1 today. Paper 1 also only section A, Constitutional and Administrative Law. And section B will take in the next session. Okay. What's your immediate reaction to this paper? Let's confine ourselves to this. Constitutional and Administrative Law, section A. Paper 1. How do you react to that? Those who have already studied this constitutional law and administrative law, or even gone through our notes or our book, my book rather, on the subject. क्या है आपका रिएक्शन? कैसा लगा आपको पेपर देखते ही? जैसे पेपर सामने आया, आपके हाथ में आया, जिन्होंने नहीं दिया अभी, उनको देख के कैसा लगा आपको? कैसे क्वेश्चंस थे? Don't you think it was really very simple? Extremely easy as compared to previous years. Why I'm saying so? Because it's not that how do we judge the paper, whether the question is, the way the question is framed. That's very important. If it's a straight question, or even if there is a statement which indicates something, a concept, it should be easily understandable and one should be able to react to that. Immediately connect with what is being asked in that question. And I found that in all the 4 questions, 4 and its parts, in this section A, I think every question was of that type where if you just read the question, you are able to recollect the concept and the contents which you want to put in your answer. देखिए, जब भी क्वेश्चन हम पढ़ते हैं, सबसे पहले हम क्या करते हैं, उस क्वेश्चन को समझ के हम ये देखते हैं कि इस पे पूछा क्या जा रहा है, और जब पूछा क्या जा रहा है तो कंटेंट आपके दिमाग में फौरन आ जाने चाहिए. Then when you write the answer on your answer sheet, it's just reframing and rearranging the contents in the manner in which the examiner wants it. So today we'll go through each and every question and see. I'll request all of you to kindly participate and give your reaction. If you read this question, what should come to your mind? That's the first thing, and that's very important in this examination.
So it was calling based.
It was?
So whatever was going, that was intimidating the paper.
So let's start with the first question. So there were, in the first question, which is of 150 words each, remember the word limit. Never ever exceed word limit. Even if you have a temptation to write more, control your temptation and restrict to the word limit. Because examiners are really very ruthless in this. They will deduct marks for, any violation of this. So there are 5 questions of 10 marks each, and it's very clearly written that answer the questions in 150 words. And 150 words, the formula is very simple. First 50 words, analyze if any statement is given or any concept is being asked, or even just named, any term is there, explain that term. In the second paragraph, that is next 50 words, you should concentrate on the legal provisions, whether it is constitutional provision, whether it is principles of natural justice or any other law, along with the case laws. Even if they are not asked, it is better to mention one or two case laws. And then in the final last paragraph of 50 words, you must conclude as per the requirement of the question. So let us go through this first question. This is the statement given. Preamble of the Indian Constitution is indicative of basic values that the political system is expected to pursue. This is, please underline this. So what comes to your mind immediately after reading this statement?
So there are basic values which are enshrined, like sovereignty, democracy, and the whole preamble itself. And
not the whole preamble. Just see. Basic values that the political system is expected to pursue. That means what? How the political system should govern. It's not the system of governance, but how it should govern. What principles the political system should follow while governing the state. And that is given in what should come to your mind immediately. See, if we see the preamble, I'll show you now after this. The preamble is divided into two parts. The first part is what type of governance model should be there. Model of governance. We, the people of India, constitute ourselves into sovereign, socialist, secular, democratic, republic. So these are the 5 elements which show what kind of governance. But what this statement is talking about, it is talking about the how governance, with what objectives the governance should be there. What should be the goal, the aims before the political system. How to govern. And that is given in the second part of the preamble.
justice, economic, political justice.
Yes. The political system has to ensure these things. And what are those things? We will see now. So the first thing is analyze the statement. Once you have analyzed the statement, you will be able to get the contents in your mind. As you said, rightly said, the justice.
Economic, social, political justice.
Yes, 3 kinds of justice. You have to ensure liberty.
Liberty, equality, fraternity.
Yes. And other things. So, first thing is, it is talking about the second part of the preamble. The objectives before the political system to pursue is expected to pursue. This is like they should do this. Okay? So we will have to in the first paragraph, we'll have to analyze and put the contents of this statement in 50 words, about 50 words. How far do you agree with the statement? Explain with the reference to values that have been enshrined in the... So it is talking about not what we are saying or what we are thinking. What is already there in the preamble, what is enshrined in the preamble. What form part of the preamble, not that what we want to add from ourselves. Once we have mentioned this, values that have been enshrined in the preamble, we will be able to connect with the statement. And that will come in our conclusion. Right? Do you agree with this? Okay, now let's see what the preamble talks about. The first part, this one, up to this, not and. And के बाद second part शुरू होगा. The first part is what type of governance we want. We constitute our system, political system, into a sovereign, socialist, secular, democratic republic. This is the first part. But this statement is not talking about this. It is talking about what? For and secure to all its citizens. This is the aim. This should be the path the political system must pursue. And what is that path? Justice, social, economic, political. Liberty, thought, expression, belief, faith, and worship. Equality of status and of opportunity. These are the things which the political system must ensure to all its citizens. Right? And promote. This is again an aim before the political system to promote fraternity, assuring dignity of the individual and unity and integrity of the nation. Up to this is our answer should be restricted to this. Okay, so we have to first identify the contents, reproduce the contents in your own words in about 50 words, 50 to 75, not exceeding that, not more than 50% of your answer. And that should connect with this. Yes. Don't immediately, when you start your answer, you don't have to write, yes, I agree. No. Unless you have analyzed, how can you agree or disagree? So first thing is, get the contents, put them in your own words, keeping word limit in your mind, and then in the conclusion you will say, yes, these are the values which the political system is expected to pursue, and this is enshrined in the preamble. Enshrined means it is the part and parcel of the preamble. And what is preamble? It is reflecting it's a mirror of the entire constitution. It's like a gist of the entire constitution. It sets the goals before the political system. You can use these words in your conclusion, in the last 40 to 50 words. Is it okay? Yes, please.
Sir, political system is expected to pursue.
Yeah.
So we can start with preamble, defining it in 50 words. Right. In the next part.
Not the entire preamble.
Okay.
The objectives set by the preamble for the political system to pursue, to follow.
Right.
That should be your first paragraph. Yes.
And to prove the point that yes, it is expected to pursue, we can use DPSPs.
They are actually DPSPs. What is the role of DPSP? DPSP is to it's a duty on the state to follow. So you have to mention DPSP also. That these goals are set in various provisions, particularly in part 4 of the Constitution, which is Directive Principles of State Policy. And also state has to ensure what? These equality, liberty, justice, how they are ensuring? By providing certain fundamental rights. Right to equality. Judicial review. Equality contains many of these factors. So you have to mention both. Creates rights in the form of fundamental rights, imposes duties, DPSP. And it is these duties which are there in part 4 of the Constitution, which the political system must pursue, follow, govern the country according to those principles. And they are all reflected in just few words in the preamble itself. Is the first question clear? The answer is clear? Yes.
Sir, question like these, generally not much of case laws come to in our mind. So in these type of questions we can avoid writing.
No, in such questions, there are no, if you start writing, decided cases, there will be a long list for each and everything you will have to. So you can avoid mentioning case laws in such questions. Right?
Right. Second question. Sir.
Yeah. No, please.
Sir, let's say we've written the 50 word first, explaining that part. Then we wrote about DPSPs.
Yeah.
Do we have to write what are the steps which have been taken in the past?
Don't write the things which will tend to exceed your word limit. But these are the things which you ought not have missed this at any cost. Because if you miss any of these factors, you are going to lose marks. In such an easy question, if you start writing things which are not immediately relevant, they are relevant. I am not saying they are irrelevant. They are relevant, but they are not relevant to the question which has been asked. Right? So restrict yourself. I know. To begin with, I told you there is always a tendency to write more if you know the contents. But restrict yourself and be very, very concise answer. Should not miss the vital parts. And you will see that if you just cover these vital, contents, your answer will be complete in 150 words. You will not exceed the word limit also. Okay? Let's go. Yes.
So introduction, you can just write what is preamble,
Don't write what is preamble. Don't write what is preamble. Just say that these are the principles, these are the basic values which are mentioned in the preamble of the Constitution of India. Start with this. And write these. Because you are short of word limit, I am telling you. If you try both the answers, but you will find that if you start explaining the meaning of preamble and write all these things, you will be exceeding the word limit. But these are the things which you cannot afford to miss.
सर इसमें केस लॉज लिख सकते हैं जैसे प्रीएम्बल इज एन इंटीग्रल पार्ट ऑफ आवर कॉन्स्टिट्यूशन जैसे ऐसा
पूछा गया है क्या?
नो सर
पर क्यों फिर लिख रहे हो? जो पूछा गया पहले वो तो लिख लो. जितना पूछा गया वो लिख लो. अगर आपके पास अभी भी वर्ड बचते हैं तो लिखना चाहो तो लिख सकते हो, पर वो बचेंगे नहीं क्योंकि 150 वर्ड्स है. Okay?
Sir, one more question.
Yeah.
Sir, like question like these, which are very simplistic in nature,
हाँ.
it may come in GS exam as well. So, do examiner expect us to write something out of the box, being an optional student, or just writing?
Use the language I am using. Use these words. This is the language of a law student. It is not for general studies. General studies, they will be using very simple language. What words we are using, they are actually the words of a law student. Okay, let's come to the second part of question number 1B. The office of the president in both the questions you will find they are starting with a statement. Right? So always underline the vital part of the statement. The office of the president under the Indian Constitution has been designed to be largely that of a figurehead. Office of the president. Yes, this designed to be largely that of a figurehead. Explain with reference to that. Now here they are asking the question, cases. So, but your answer should not start immediately with the cases. What we have to do first?
Underline.
Underline तो कर दिया. आगे contents. क्या कंटेंट्स कहाँ मिलेंगे आपको ये?
सर की पॉइंट को पहले एक्सप्लेन करना।
क्या है की पॉइंट इसमें? इस क्वेश्चन में व्हाट इज द की पॉइंट? Office of the President is figurehead. That means the real executive powers lie somewhere else, but they are exercised in the name of the President. He is a constitutional head of the state. कहाँ मिला ये? Powers of the President part में है कि नहीं? Refer to that. Power of the President. So, what is there? Let's see. Formally vests functions in the hands of the President. Where lies the executive power?
Executive power lies in the Council of
Council of Ministers. And how President functions? On the aid and advice of the Council of Ministers. So these are the words you cannot afford to miss. That means real executive is with the power is with the Council of Ministers. The President has to act according to the aid and advice of the Council of Ministers headed by the Prime Minister. राइट? ये कंटेंट में आ रहा है ना अपने दिमाग में?
Yes.
अब एक बार आ गया, अब उसको हमने वर्ड्स में लिखना है एंड देन वी हैव टू कनेक्ट दैट विद द डिसाइडेड केसेस. ओके, कंटेंट समझ आ गया, कंटेंट दिमाग में बैठ गया, अब उसको सिर्फ वर्ड्स में कन्वर्ट करना अपने वर्ड्स में. In reality, he has considerably less function to discharge his discretion. His discretion is very limited, right? Or his individual judgment. Very keywords. Very keywords. The President is the constitutional or formal head of the Union, and he exercises his powers and functions conferred on him by or under the Constitution on the aid and advice of the Council of Ministers. Don't mug up this. If you have understood, write in your own words. These statements are mentioned here not for mugging up. रटना नहीं है इनको समझ के अपने वर्ड्स में लिखना है, but meaning should be what meaning it should convey? It should convey the same meaning as it is written here. Your word should not change the meaning of this thing. Now, Supreme Court has consistently taken the view that the powers of the President are similar to the powers of the Crown under the British parliamentary system, because we have followed that system. If the word limit permits, write this, otherwise no need. Again, I am telling you. But what you should not miss is one landmark, this case. Ram Jawaya Kapoor versus State of Punjab, 1955. Even if you are not able to remember the exact year, चलेगा. केस का नाम जरूर लिखना है, क्योंकि यहां देखिए that though the executive power is vested in the President is only a formal or constitutional head of the state, head of the executive. And you have to add one more thing. All the executive orders are issued in the name, or the governance of the state is carried out in the name of the President, by order of the President. President is pleased to appoint so and so. President is pleased to remove him from service. So President is always pleased, while appointing and while removing also. Dismissing also. But anyway, you don't have to write all these things. It's just for our understanding that every order is issued in the name of the President. But how this order is issued? This order is issued, it's an executive order. It's the decision of the Council of Ministers. which the president has to follow as the constitutional head of the state. So we can say it's like this. We are coming very close to this term. Aren't we? Right. The real power is vested in the Council of Ministers, on whose aid and advice the president acts in the exercise of his functions. इतने में ही आपका 150 वर्ड पूरा हो जाएगा कि नहीं होगा? हो जाएगा. Simple. So, contents are clear. How to write? First paragraph, explain this statement. What is the function of the president? Then how he exercises his function. Case law, second paragraph. And then in case law also, you don't have to write the exact words. You can say in this case, the Supreme Court has decided that he is only a constitutional or formal head of the executive. The real executive is with the Council of Ministers. Hence, you agree with the statement. The statement is right. Yes.
सर जो केस लॉ होते हैं किसी भी अगर कोई लिख सकते हैं क्या केस लॉ
आपने बीच में लिखना
बीच में लिखना
कंक्लूजन में तो आप बता रहे हो कि इस स्टेटमेंट से पूरा जो आपने लिखा है वो सारा उससे एग्री करता है, उससे कनेक्ट कर रहा है. पहले वाला जो क्वेश्चन था उसमें भी तो यही था, डू यू एग्री? एंड कंक्लूजन में लिखो यस आई डू एग्री इन द लाइट ऑफ द अबव डिस्कशन. वन सेंटेंस, दैट्स ऑल.
सर जैसे बिगिनिंग में स्टार्ट से कर सकते हैं द कॉन्टेक्स्ट ऑफ इंडिया द प्रेसिडेंट इज द नॉमिनल हेड ऑफ द स्टेट.
क्यों सीधा ही कंक्लूजन पे जंप कर जाएंगे? पहले बताएंगे ना क्यों इस कंक्लूजन पे पहुंचेगा. ये आपको पहले ही पता है आंसर. पहले तो उसको एनालाइज करोगे ना, कॉन्स्टिट्यूशनल प्रोविजन बताओगे, केस लॉ बताओगे कि उसमें ये किया गया, इसलिए आपके कहने से वो नहीं है फॉर्मल हेड, वो कॉन्स्टिट्यूशन में है, कॉन्स्टिट्यूशनल प्रोविजंस में है और केस लॉज में उसको रीइटरेट किया गया है, इंटरप्रेट किया गया बाय द जुडिशरी. राइट? यस
सर, लेट्स से थोड़ी वर्ड लिमिट बच जाती है, उसके प्लेजर डॉक्ट्रिन के बारे में
बिल्कुल नहीं. फालतू चीज क्यों लिखेंगे हम फालतू? आपके बचेंगे नहीं, आप लिखिए, आंसर लिख के देख लीजिएगा. यू राइट ऑन दीज लाइंस, यू विल बी स्टिल सेइंग सर इसी में ही 5-10 वर्ड सक्सीड हो रहे हैं. सो डोंट राइट इररिलेवेंट थिंग्स. या okay, now we come to the yes please.
So can I take a screenshot of that?
Please do take. You will get a recording of this also. But anyway, if you want to take, you are welcome. Right. So we come to the third C. Yes, please.
सर जैसे आंसर राइटिंग करते हैं उसमें ऐसा होता है कि इंट्रोडक्शन पार्ट और बॉडी पार्ट हो जाता है, तो कंक्लूजन में थोड़ा प्रॉब्लम ये होती है कि मतलब उसमें कंक्लूजन पे कैसे पहुंचे.
क्योंकि अगर आप मेन मुद्दे से भटक जाएंगे तो कंक्लूजन कुछ और निकलेगा और ऊपर कुछ और लिखा होगा. अगर उसी लाइन में लिखते रहेंगे, उसी को एक्सप्लेन करेंगे, उसी में ही प्रोविजनल जो स्टैट्यूटरी प्रोविजंस है, कॉन्स्टिट्यूशनल प्रोविजंस है वो डालेंगे, केस लॉज डालेंगे, तो इधर उधर जाएंगे ही नहीं. आपका कंक्लूजन में दोनों एक ही लाइन में रहेंगे, अलग अलग लाइन में अलग रास्तों पे नहीं चलेंगे. Right? Let's come to the third. There is an obvious slant in the favor of the center in distribution of power. Obvious slant in favor of center here. Distribution of powers between center and states. So, where your mind should go immediately? Distribution of powers, center-state relations, isn't it? Center-state relations. Now, in the distribution of powers, you have what? Where is the distribution of powers?
lists
In the
schedule.
सेवंथ शेड्यूल
7th schedule, 3 lists.
स्टेट लिस्ट
Central union list, state list, concurrent list. That is one part. But what is there in the mind of the examiner? He's not asking you how this distribution of powers is. He's just focusing only on one issue, one part of that, and that part is the shift, the weight, the slant towards पलड़ा जो थोड़ा सा भारी है वो किसका है? सेंटर का. So you will have to focus only on those areas where center is getting more powers. Even in the list, the residuary powers are with the center. In the case of emergency, there are emergency provisions 352, 356, 360, where the governance comes to the center. The whole federal structure gets tilted towards a unitary function. That should be. Let us see. Then, do you agree with the statement? Don't write in the beginning, yes, I agree. How do you agree? Unless you have written the whole thing. Unless you have explained this statement, how can you reach a conclusion? So this should come in your conclusion. So explain. Let us start with the explanation of this statement. This is just an indication. Look at this. The legislative relations. Right? Even if you write in points, no problem at all. Territorial jurisdiction, distribution of power, 3 lists, Goods and Services Act, special provision, residuary power with the center, repugnancy, inconsistency between laws, the central law shall prevail. Right? Then control of union over the states. These are the contents which we have to write in the answer. Direction by the union to the state government. Delegation of union function to states. All India services. आपकी अपनी 312, Article 312. Grants made. Which center will roll out to the states. It's their decision. Right. So, then full faith and credit clause, these are the relevant articles. If you remember them, well and good, at least write a few which you know very well. The scheme of distribution of sources of revenue between center and states is based on the scheme laid down under this, the Government of India Act 1935. But if you want to mention, if words permit, do, otherwise please leave it. Right? So, international relations, they are all part of this central. Yeah. So, these are the contents which you have to write in your answers. Don't miss out on any of these. We have already discussed all these in our sessions. एक मिनट रुक जाओ. And they are there in our notes in complete details. इतने ज़्यादा detailed notes हैं आपके पास. Everything is covered in this. Or refer to my book. हाँ तो notes ही आए ना ये. आपको notes में exactly वही मिल रहा है जो question में पूछा गया है. क्लास में भी यही पढ़ाया गया था, जो एग्जैक्टली यही पढ़ाया गया था, इन्हीं वर्ड्स में पढ़ाया गया था, isn't it? चलिए, let's come to fourth one. The principles of natural justice are not cast in stone. इसको ये करिए, principles of natural justice not cast in stone, number 1. And there is always possibility of deviation from stated principles of law in view of the overall demands of justice. So this statement consists of two parts. Both are, of course, related very closely. The first part says what? They are not rigid. Principles of natural justice are not rigid. They are not cast in stone. That means they can evolve according to the needs of the situation. What is the purpose of principles of natural justice? To deliver justice. Overall demands of justice. So you apply principles of natural justice to get justice. We'll see how they have evolved. That will come in the contents. First explain this, that they are not rigid. They are not cast in stone. Don't use this term in your explanation. Just use, they are not rigid. There can be new addition, there can be new interpretation of principles of natural justice or in their application in given situations in getting the justice as the justice demands. Right? We'll have to see how they have done. Like, what were the original principles of natural justice? There were hardly two. One was odi altum partum. Second is biasness. That means nobody should be a judge of his own cause. These were the earlier two ones. Now, new have been added. The scope of principle of natural justice is being widened. It is getting widened. How? By ensuring what? Fairness, reasonableness. और जब आप fair, reasonableness की बात करते हो, just की बात करते हो, what case law should come to your mind? Menka Gandhi's case. That is a new aspect added to principles of natural justice. That means when the authority will become reasonable, just and fair, when they give reasons for their actions, for their decisions. That means reasoned decisions. So reasoned decisions is the new aspect of principles of natural justice. समझ आ रहा है? अब देखिए, explain citing this. बचा क्या इसमें? We have got the contents, we have got the cases, you have to just write it in 150 words. How simple it is. Let's see. They are not codified canons. They are, these are the words used by various jurists. They are principles ingrained in the conscience of a man. That's why they are called natural justice, principles of natural justice. P.K. Roy case. Natural justice cannot be imprisoned within the straight-jacket rigid formula. They are not rigid. So, traditional approach is this. Nobody should be the judge of his own cause. That is rule against biasness. And odi altum partum. No person should be condemned unheard. This you have to explain, please. And what is new addition, modern approach, is reasoned decisions or speaking orders. Speaking order वो होता है जिसमें reasons are mentioned. Why a particular decision has been taken by the authority. Right? Now we come to the fifth question in the...
Sir.
Yes, please.
Sir, in the previous question,
Yes.
is this question asking for exceptions of natural justice?
Is this question asking for?
Exceptions.
Exceptions of natural
No. Where it is asking exception? It is not talking about exception. It is only saying that the principles of natural justice are not rigid. They cannot be put in a straight jacket. codified in limited words. They can be evolved in view of overall, when the justice demands, the new principles can be added. Here is the example. Here are the case laws. 2 case laws are there. So it's not exception. Please, what makes you think that it is an exception? No. Nowhere. It doesn't say exceptions to principle. No. Question is not demanding that. Question is demanding what is the changing? Can there be new principles of natural justice or new aspects of of natural justice to deliver justice? And what better case can be there than Maneka Gandhi's case? Right? Okay.
Thank you.
Welcome. Now we come to the 5th part of question number 1. Explain and elucidate the grounds of judicial review for administrative action. This is again a question on administrative law. We have studied judicial review of administrative action, but anyway, just underline this. Grounds of judicial review for administrative action. So you have to stick to this. And in administrative action, what could be the ground? Arbitrariness, bias, different kinds of bias, subject matter bias, this, that, which we have already got in our notes and the book. So you have to pick up those grounds only. Don't write anything else, please. So grounds of judicial review. So what is judicial review? Judicial review is by the Article 32 Supreme Court or 2 to 6 by the various high courts. Where and how you will connect it with the administrative action? When an executive action or the administrative action is violating the fundamental rights or any other legal right of a person or a citizen, we can approach the highest court of the country under Article 32, which itself is a fundamental right. So judicial review is itself a fundamental right. But here you don't have to explain all those things, just for your understanding. You have to say, yes, these are the grounds where the administrative action can be brought before the judiciary for their review, right? By quoting decided cases. अब आपको कंटेंट समझ आ गया मोटा मोटा, decided cases भी देख लेते हैं and the answer will be complete. Let's see this. Again, first is what is executive action? What is administrative action? The best case on this is Ram Javaya Kapoor case versus State of Punjab 1955. What does it say? Say administrative action is the residuary action which is neither legislative nor judicial. Very, very important statement, very, very important decision on administrative. What constitutes administrative? Because this you have to write in your answer. होता क्या है administrative action? जिसको आप चैलेंज करने जा रहे हो, जिसको जुडिशियल रिव्यू के लिए लेके जा रहे हो, वो समझाया इस केस से एक लाइन, बस इससे ज्यादा नहीं लिखना. Now you have to write the grounds, and these grounds are there in your notes, isn't it? है ना?
Yes.
किताब में भी है, बुक में भी है. चलिए देखते हैं. Malafide, colorable exercise of power, unreasonableness, procedural impropriety, judicial discretion, proportionality, doctrine of legitimate expectation, illegality, doctrine of public accountability. These are the broad. Try to write as many as you can. It may be difficult to remember all of them, but since you are preparing for such an exam, it is expected that you should know a majority of them, rather all of them. पर रटना नहीं है. फिर मैं वही कह रहा हूं, देखिए, एडमिनिस्ट्रेटिव एक्शन से ही आपके दिमाग में क्या आता है? अगर कोई एडमिनिस्ट्रेटिव एक्शन से आप खुद अफेक्टेड हो तो आप क्या कहोगे? नॉन एप्लीकेशन ऑफ माइंड, अनरीजनेबल, मेलाफाइड की, ठीक है, एक्सीडिंग हिज पावर्स, यही तो आता है ना। हम रोज यही तो कहते हैं, अगर हमारे पास कोई गलत ऑर्डर आ जाता है, यू आर नॉट गिविंग ए लाइसेंस, यू आर नॉट गिवन ए लाइसेंस बाय द लाइसेंसिंग अथॉरिटी, आप कहोगे उसको दे दिया मुझे नहीं दिया, आर्बिट्रेरीनेस, राइट, इलीगैलिटी, ही हैज डन एन इलीगल एक्ट, ये अपने आप आएंगे आपके दिमाग में once you start connecting with the real life situation. And again I'm saying these are all available in the notes as well as in the book. मैं यहाँ पे प्रचार नहीं कर रहा, मैं कोई यहाँ पे किताब या नोट्स बेच नहीं रहा, मैं सिर्फ आपको ये बता रहा हूँ कि this material as it is has been taught to you, has been, you have been guided on all these issues which are there in these questions, 5 questions which we have discussed. Each one of them, word by word, you have got the answers. You have been taught in the classroom itself in the sessions. You can go back to our previous videos and you will find answer in the same words, in the same manner, which I am explaining now. Okay, now we come to the second question. It has got another parts, but if you see this question, let me see question number 2. The first part is, that is A, 2 A's of 20 marks. What does it mean? What is your word limit now? वहां 10 थी, पर वहां पे यहाँ 300 नहीं हो जाएगी. Marks are doubled, but word limit is 250. Though it's not written here, but this is what the formula the UPSC follows. Right? Let us see this. The Constitution of India has provided a clear-cut distinction between civil and political rights on one hand and economic and cultural rights on the other. This is the first part of the statement. Clear-cut distinction between, so the question, the statement is revolving around the rights have been divided into 2 broad categories. Are you able to get it? So what is the first category? Civil and political rights, and on one hand, and economic and cultural rights on the other. First is, there is a distinction in the Constitution of India. So first, we have to explain, since 250 words means you have an answer, the first part of the answer should be about 100 words, isn't it? 100, 150. Conclusion should not exceed 50 words. First part 100. So first part means you have to explain these two. What are civil and political rights? What are economic and cultural rights? And how there is a distinction between the two in the Constitution of India. Right? Having done that, we move on to the second part of the statement, which says, with a distinct primacy given to civil and political rights. That means we will have to look at the civil and political rights vis-a-vis, because we are already in the first part, we are doing the distinction. So what should come out of it? Whether this hypothesis is correct or not. कि जो civil or political rights are, they are given primacy in the Constitution. So first, पहले देखते हैं कौन-कौन से rights हैं. How you will put right to equality from 14 to 18? Which category? Civil, of course. Freedom, again civil. Civil, political, you can say both. Right against exploitation, again same. अब
Cultural.
ये जो 3 राइट्स हैं, सॉरी, ये दोनों, दिस एंड दिस, दे आर कल्चरल एंड इकोनॉमिक राइट्स. कैसे? ये देखिए, कल्चरल, एजुकेशनल राइट्स, इसी में ही इकोनॉमिक राइट्स भी आ जाते हैं आप. Right? Minorities given certain economic rights, certain cultural rights, establishing their own educational institutions, etc. Freedom of religion, it's also a cultural right. Religion comes under culture. Come to the last one, 32. Constitutional remedy. It is a civil political right. Some jurists have said that judicial review or 32 is the heart and soul of the Constitution. These are the things you have to write. तो पलड़ा किस तरह भारी है? Certainly. अब आप बताइए, आपको ज्यादा लिखने की जरूरत पड़ेगी इसमें क्या? You first divide them. These are the fundamental rights. Divide them into these 2 categories. ये ऐसे. और उसके बाद draw out a distinction between the 2. What are civil and political rights aiming at? Are they not available, most of these rights available to any person, not only to citizens, but to any person? Right to equality 14. 15, 16 नहीं है, 19 भी नहीं है, it's only for citizens. But then look at this, 20, 21, 22. Right to life, personal liberty 21. Right, protection. Those are all called protective rights, which are available to any person. And the privileged rights are only available to citizens, which grant certain privileges to the citizens of the country, not to everyone, not to non-citizens. You have to draw these distinctions in your answer. You have to mention this also. Mention this aspect also, protective rights, privileged rights. Then privilege in the form of what? Then you draw the distinction between cultural and economic rights. How they are different here. And then you say that definitely there is primacy. It's very clear. Yes.
Sir, we can also, there are most of the economic and cultural rights are enshrined in DPSPs. So we can also compare.
Yes, I am just talking about one aspect, fundamental rights. We are coming to that. Yes, you have to mention DPSPs also, where what are those economic and cultural rights which talk about social justice, which talk about socialist structure of economy, 39B and C.
Participation of labor.
Yes, protection of labor, this, that. These are all, but they are not in the form of rights, enforceable rights. They're not in the form of, that's why I am taking them only in just, you can just mention them in 1 or 2 sentences, that's all. Because they are not rights. They are the directions to the state how to govern, how to have a welfare state. Right? Clear this? Can we move forward?
So some of the economic rights are also given in trade, etc. in the later part of the Constitution.
There are other legal rights, constitutional rights, other than fundamental rights. Like you have right to property, which is no longer a fundamental right. But it is under Article 300A, under 44th Amendment. It was earlier a part of Article 19. It's no longer a fundamental right. It's only a legal right now. right? So there are various economical rights which find place in other parts of the Constitution, but they are not rights which are enforceable as fundamental rights. Right? Clear? Chaliye. Now, question 2B. 2B is 15 marks, maximum 200 words, proportion में, right? So you have to reduce. ये करना है आपको, ये सिर्फ प्रैक्टिस से आएगा, right? पंचायती राज institutions and urban local bodies have been accorded constitutional status. This is the statement. What put them in the Constitution? How they became the part of Constitution? By 73rd and 74th Amendment. Right? 73rd Amendment is Panchayati Raj institution. 74th Amendment, urban local bodies.
इसका कमेटी का नाम लिख सकते हैं।
आ रहे हैं लिखेंगे क्योंकि 200 वर्ड्स हैं तो लिखना पड़ेगा आपको. Now, not all the committees, the main committees, right? You can write, but first your answer should start with this. कि इस जो स्टेटमेंट में लिखा है कि ये दोनों कॉन्स्टिट्यूशनल स्टेटस दिया गया है इनको, कैसे दिया गया? वेरी फर्स्ट थिंग, ऐसे दिया गया. वो ये नहीं पूछा क्यों दिया गया, किसकी रिकमेंडेशन पे दिया गया. क्वेश्चन को देखो ध्यान से, फालतू नहीं लिखना. वर्ड्स बचते हैं तो लिख लो कुछ भी का मतलब. यस प्लीज.
So that means introduction should be in consonance with the starting.
It has to be. I tell you, the examiner, once he starts reading your answer, if it starts on this note, he will be compelled to read your entire answer with a different frame of mind, and you have every chance to get very good marks. Right? It has to be very, very crisp, to the point. What is being asked here? Or what has been mentioned here? Just explain that. Explain the ambit and structure of the authority of Panchayati Raj institution and under the... Now, this is the second part. First part is under what provision of the Constitution they have been given a constitutional status. Then, what are Panchayati Raj institutions? What are urban local bodies? ये लिखेंगे. Then you have to see the structure, ambit and structure of the authority. How do they function? If you talk of Panchayati Raj institution, there are 2-tier system, there are 3-tier system. You have to mention that also. Some states follow that, some states. But they have to follow this. They must have Panchayati Raj institution, they must have local bodies. It's mandatory, it's a constitutional provision. They must have this, but they can choose to have either 2-tier system or 3-tier system. That is left to the states. Similarly, there are certain criteria has been mentioned as to what will constitute a municipal corporation, a municipal council, municipality, your township, right? Cantonment, port, like that. So you have to mention them and their structure and functioning. Functioning means their ambit and structure of the authority. What is the authority of these institutions? What do they do? Structure, ambit and structure of the authority. Right? This should be your beginning of the answer. Then 3-tier system, 2-tier system. ठीक? Come to urban local bodies. Then you have to mention their structure and functioning. Right? इससे ज्यादा तो कुछ नहीं पूछा गया ना इस क्वेश्चन में. है कोई गुंजाइश लिखने की कुछ और? You don't need to. Your answer is complete with this. This means not these, just mentioning these. You have to explain what is Gram Sabha, what is Jila Parishad, where there is a 2-tier system, and what is the middle tier, block level, mandal. Right? On this side, municipal corporation, municipality, notified area, town area, cantonment board, which are under the Ministry of Defence. Township is for where any industry is being developed, that area is declared as township. Their functions are different, their structures are different. That is why it is 200 words. You have to mention in one sentence each of these. They're all, again I'm saying, all given in your notes, in detail, in the same words as I'm uttering. Again, in the book and the notes. And they have been taught in the class also. Yes, please.
Sir, this whole suffice the structure thing. The ambit comes before and
Ambit means scope of their functioning, scope of their authority. कहाँ लगेगी? Territorial and functional authority. Territorial authority and functional authority. What are their functions?
kind of function.
Yes. Yes. ठीक है जी, चले आगे. चलिए. C part. Again, 15 marks. 200 words approximately, but not exceeding this, please. The Constitution of India provides constitutional status and protection to civil servants. Now, if you see, when you read this statement, immediately it should come to your mind Article 309, 10, 11. 309 is civil servant, 310 is doctrine of pleasure, and 311 is a restriction on the doctrine of pleasure, isn't it? It provides for inquiry, provides for certain procedure to be followed if a civil servant has to be punished. So, let's see the next part. So, constitutional provisions you have to mention. You start answer with these 3 articles. ठीक है जी? What protections have been secured for civil servants in India? That is given in where? 311. Straight. Explain. क्या बचा बताइए. But only thing is, you have to elaborate them. 310, doctrine of pleasure, you have to write what is doctrine of pleasure, from where we got it, right? 311 is the second part of your question, which says, what protections? That means, under doctrine of pleasure, anybody can be thrown out, any civil servant, as long as the pleasure of the appointing authority is concerned. If that pleasure is withdrawn, he is out. But no, 311 says you can dismiss, remove or reduce in rank after an inquiry is conducted. And then there are exceptions to that also. Under what conditions the inquiry need not be held. So this is part of 311. You have to explain, write this in your answer. Right? Pleasure is 310, controlled by the, that is, protection is given against the doctrine of pleasure. In accordance with the procedural safeguards provided by Article 311. Right? General principle relating to civil services has been laid down in 310. 11 imposes restrictions on privilege of dismissal at the... What is the difference between dismissal and removal? In the case of removal, the person who is removed from service is eligible for re-employment, but not in the case of dismissal. Right? Okay. Is it clear? So, should we move on to the next question? That is question number 3. Yes. It has got 3 parts. Again, 20, 15, 15 like question number 2. This is 20 marks, 250 words. Superintendent's direction and control of elections is vested in the Office of Election Commission, and therefore the appointment of election commissioner is of crucial importance in conducting free and fair elections. This is the statement given. Now let us underline the key parts of the statement. Superintendent's direction and control of elections. That means the entire process of conducting elections is controlled by whom? As per the provisions of the Constitution, the Election Commission of India. Thick is vested in the office of the Election Commission. Up to this. Now, how this is done? How the superintendents, the control, the direction, how it is brought under the control of Election Commission of India? कैसे आता है उनके कंट्रोल में? Right? And the purpose, the objective is to conduct free and fair elections. For this objective only, the entire administrative machinery connected with the conduct of elections is brought under the Election Commission, direct control of the Election Commission. Election Commission can remove anybody, can suspend anybody, can transfer anybody, can take disciplinary action against any civil servant, any person who is connected with the conduct of elections. That is a huge power, isn't it? Once the elections are announced, the entire machinery, or even when the electoral rolls are being prepared, the entire machinery connected, because that's also part of election work. Including the district collectors who are the district election officers, the returning officers, the presiding officer in a booth, the polling officers, the other officers, the police officials who are conducting the elections, the free and fair election, ensuring free and fair elections. No violence takes place. Then, model code of conduct. For everybody, for political parties, for the contestants, for the government, for the administration, everybody comes under that model code of conduct when the moment the elections are announced. It comes into force. Huge powers. These are the powers of the Election Commission to ensure fair and free elections. This has to be the beginning of your answer. Complete. Then come to the next part. Critically examine the above statement with reference to recent judicial decisions. You know, when we talk of contemporary topics, contemporary developments in law, this is the question. अभी क्या हो रहा है? क्या controversy चल रही है? What Supreme Court has held? What should be the selection committee consisting of with respect to appointment of election commissioners? And what bill has been introduced? What changes? What is the judgment and how it is being taken care of, or rather, modified in the bill, which has not yet become, but it should find place in your answer. That's the recent development. Judicial decision as well as a follow-up of that. Whatever action is being taken till date, don't say or don't think that the question was prepared 3 months back, 2 months back, and now how the examiner will, expect that I should give what happened yesterday or a week before. No, they expect that only. That's why this has been added. Right? This is the case. Recent case. A 5-judge constitution bench of Supreme Court, of course, modified the process for appointing members of ECI and held that a committee comprising the Prime Minister, the Leader of Opposition, Chief Justice of India, will advise the President on who appoints President. So, the advice, who will give this select committee, this selection committee, okay? Now, this bill has been introduced in Rajya Sabha on this, if you remember the date, well and good, otherwise, recently gather, which proposes that CEC and other ECs, there are 3, 1 CEC and 2 election commissioners, will be appointed by the President on the recommendation of a selection committee, where PM as chairperson, Leader of Opposition in Lok Sabha a member, and a Union Cabinet Minister nominated by the Prime Minister. No Chief Justice. Yeah. And then, since Prime Minister is the chairperson and the other member, it's a 3-member committee, so majority decision will be taken by these 2 persons. If Leader of Opposition doesn't agree, don't write this in your answer, just for your understanding. Yeah. Yes, please.
So it is challenged also. So
Pardon?
So the bill was challenged. It's on the verge of challenge.
Bill cannot be challenged. Only when it becomes a law, it will be challenged. You'll see that. First, let it become a law. But this you have to, these are the recent judicial decision and the aftermath of that. This must find place in your answer. Without this, your answer is incomplete. Rather, I'll say 0 mark. ये समझ लीजिए. This is what the examiner wants from you. चले आगे? चलिए. B, 15 marks, 200 words. Legal aid provides a basic tool for access to justice for poor and marginalized sections of society. What is this legal aid?
Provide lawyer to people who cannot afford it.
Any legal assistance. Aid means assistance. To whom? Keeping in mind the poor and marginalized sections of society who cannot afford legal assistance. Discuss and elucidate constitutional provisions and the provisions of Legal Services Authorities Act. Clear? आ गया दिमाग में क्या लिखना है?
लोक अदालत से डिफरेंट.
हाँ जी?
लोक अदालत जो होता है उससे डिफरेंट.
इसमें आएगा नालसा, स्टेट एंड डिस्ट्रिक्ट legal authorities, legal services authorities. Okay? This you have to mention. You should start writing with this. What is the object? Why do you need legal aid? Right? Write this also. In addition to this. Start with the preamble because they are saying constitutional provisions. कहां से निकल के आ रहा है ये लीगल एड का कंसेप्ट? इक्वल प्रोटेक्शन ऑफ लॉस, Equality before law and equal protection of laws is Article 14. State now, this is DPSP 39A, capital A, introduced by 42nd Amendment. What it says tells the state what they should do. Frame a policy for providing free legal aid through passing legislation or schemes to ensure that opportunity of securing justice is not denied to any citizen by reason of economic or other disability, poor and marginalized. आ गया? Then you have the second part of this question. Provides for establishment of legal service authority at national, state, district level, even at taluk or mandal level also. Right? You have to, I'm just giving you the framework. You have to explain, elucidate, write in detail about this, subject to the word limits. इधर उधर नहीं जाना, जो लिखा है बस उस हिसाब से चलो, जो क्वेश्चन में पूछा गया बस उतना ही लिखना है. Right? चलिए, we come to C. 3C is again 15 marks, 200. The strength of eminent domain is inversely proportional to the strength of democratic structure of any system. Answer कहाँ से शुरू होगा? यहाँ से. What is this? Right? How the democratic system works, democratic structure of the system in India works. ये होगा आपका explaining the statement. अभी भूल जाओ क्या है इनवर्सली प्रोपोर्शनल को, पहले इन दोनों को एक्सप्लेन करो अपने आंसर में. And then this proportionality or inversely proportion will automatically come out of it. कैसे? State takes over the private property of the individuals for public purposes. Right? How right to property was removed as a fundamental right and taken to as a legal right, 300A, a constitutional right. Eminent domain emerges from the basic concept that all property belongs to state. It has an inherent sovereign domain. Sovereign domain of the state. Because it is based on the premise that all property belongs to the state. It is tilting towards what? Towards the public purpose. The public purpose overshadows the private right. That's why this private right was taken away from the list of fundamental rights and put as a constitutional right. ठीक है? Property shall not be taken for public use without just compensation. This is what the right gives. Property can be taken, but after paying a just compensation, for which laws will be enacted. So, welfare of the common people is paramount. This is the basis for this doctrine of eminent domain. And second is, public necessity is greater than private necessity. Now you come to how it is inversely proportional. Isn't it clear now? It is emerging. एक तरफ public right है, एक तरफ private right है. So private right will go if there is a public need. That is what the doctrine says. Getting it? So, do you agree with this statement? You will write in the, because once you write all this, it becomes very clear. Yes, they are not exactly inversely proportional, but yes, they are serving different purposes. And the purpose on which this doctrine works overweighs the private right, which has been now clear from this also. Right? Give this case. So what are the conditions? The existence of public purpose, payment of compensation, and acquisition must be done by the authority of law. That's what I said, there must be a law. Maybe Land Acquisition Act, rules framed thereunder. Compensation must be paid and the public purpose must be clearly defined. Then only you can exercise this. Clear? Anything else you want from this?
So,
Yeah?
do we have to explicitly write that inversely proportional?
No, don't write in clear words. He said, they serve different purposes. But the public purpose, that is the doctrine of eminent domain, overshadows the private right.
And does that support democracy or makes?
It supports democracy because it's part of the constitution. The system, even the Supreme Court here also says, you must have these three tests fulfilled, these three conditions fulfilled. Then you take away the private property.
So individual right to compromise हो रहा है ना?
हाँ, हो रहा है, बिल्कुल हो रहा है, लेकिन किस लिए? In the larger interest of the public. So individual right takes a back seat when it comes to public purpose. Clear? चलिए. Now we come to question 4, part A. Right? Which is 20 marks again. 250. What do you understand by the breakdown of constitutional machinery? You have to explain, start your answer with this. What is the breakdown of constitutional machinery in a state? Critically examine the powers of the president. This is second part. First part is this. You have to explain this. What is this? Then critically, when it comes to critically examine, means you have to write both the aspects, for and against, and then come to the final conclusion in the light of the constitutional and other statutory provisions as well as the case laws. Right? Now, the powers of the president in imposing president's rule under 356 by citing decided cases. Now, don't you think that this is one of the basis for imposing president's rule? Breakdown of constitutional machinery in a state. So if you have explained well what is breakdown of constitutional machinery, half of your answer is already there. Now, president's power. How the president will reach this conclusion? Whether there is breakdown of constitutional machinery or not. Not only on the governor's report. Even if there is no governor's report, still, otherwise also. Yes, what is the basic thing? Aid and advice of the Council of Ministers. He has to go by that. He has very little discretion. Yes, the governor's action, assessment about the breakdown of constitutional machinery in the state. First is, what is breakdown of constitutional machinery? That means the state governance is not being carried out as per the provisions of the constitution. It can be any provision. So, if there is a report, fine. If there is no report, again, president will go by the aid and advice. Now, when you say critically examine, how you will criticize this? Because the assessment of the governor in his report is very subjective, is subject to mala fide. And that point can be a subject of judicial review. and which has been held in the Rameshwar Prasad's case also, SR Bomai also. These are landmarks, so we have to mention that. अभी आप खुद ही बता रहे हो, आ रहा है ना दिमाग में, एकदम से आता है, ठीक है. Now let us see satisfaction. This case is very important regarding satisfaction of the president, because unless the president is satisfied, how he will promulgate 356 does not mean the personal satisfaction, but satisfaction of his Council of Ministers. Sarkaria Commission report. Failure into political crisis, internal subversion, physical breakdown and non-compliance with the constitutional directions. We have seen in one of these earlier questions what? The center can issue directions to the states.
Article 365.
Yeah?
Article 365.
Yeah. So, that can be one of the grounds. They are not. Because that's a constitutional provision. If a state fails to obey the directions issued by the center as per the provision of the constitution, that means they are going against the provisions of the constitution, and it will come under this category. So, SR Bomai, extraordinary one, needs to be used sparingly when the situation contemplated warrants to maintain a democratic form of government. Then, Rameshwar Prasad's case, governor misled the Council of Ministers on whose advice the proclamation. So, how the Council of Ministers reached a particular, decision about imposition of 356? Yes. In this case, it was governor's report, which was held to be mala fide by the Supreme Court. They said misled, sent a wrong report, right? And based on a wrong report, an advice was given to the president, and then 356 was imposed. Is it clear? Do you have any doubt on this? Yeah.
So can we quote Ambedkar's some thought like in this case?
If you have the word limit, please ask the question.
Yeah. So in case like he said that the only expectation he has from the government is to maintain national security and political stability. The political stability part fixes in this one.
Why you are stretching it too far?
We don't
need to. Stick to what is written here. You don't have words. भाई इतना ही लिख लो बहुत है, इसको डिटेल थोड़ा सा एक्सप्लेन करके. हाँ जी, somebody wanted to ask something.
सर क्या गवर्नर से भी परमिशन लेनी चाहिए? मतलब अगर राजस्थान की केस में मतलब जैसे आप बोल रहे हो, क्या गवर्नर से भी परमिशन ले सकते हैं क्या?
कोई जरूरी नहीं है. गवर्नर की रिपोर्ट हो या ना हो, परमिशन नहीं होती, उनकी रिपोर्ट होती है. और मैं आपको एक तमिलनाडु का केस बताता हूं. इन 1991 the central government asked the then governor to send a report that there was a breakdown of constitutional machinery, which then governor, जो उस टाइम पे वहां गवर्नर थे, उन्होंने मना कर दिया 1991 में. और सेंटर ने फिर भी वहां की गवर्नमेंट को बर्खास्त कर दिया 356 में. क्यों किया? क्योंकि गवर्नर की रिपोर्ट मैंडेटरी नहीं है. मैंडेटरी क्या है? एडवाइस ऑफ द काउंसिल ऑफ मिनिस्टर, जिसके ऊपर प्रेसिडेंट एक्ट करेंगे. उस एडवाइस को बनाने के लिए गवर्नर की रिपोर्ट हेल्प करती है, मैंडेटरी नहीं है. ठीक जी.
अभी एक सर लेटेस्ट केस पंजाब का गया था, जिसमें सर गवर्नर उसको बोले थे सर रिपोर्ट उसको कुछ जितना 50,000 करोड़ खर्चा किया.
अरे यार क्या तुम ना बातें कर रहे हो. दूसरी तरफ कहीं और निकल रहे हो। चलिए, अबाउट दिस ब्रेकडाउन ऑफ कॉन्स्टिट्यूशनल मशीनरी, रोल ऑफ प्रेसिडेंट, सेटिस्फैक्शन ऑफ प्रेसिडेंट, हाउ प्रेसिडेंट एक्ट्स, right? And what is the criticism? Okay, it's a very subjective satisfaction. So it can go either way. That's the only criticism we can say, and we must write it. Okay, we come to second part of question 4. ये भी है 15 मार्क्स का और 200 वर्ड्स लगा लीजिए। Discuss the objectives of establishment of Lokpal and Lok Ayukt and their powers and functions under the Act, Lokpal Lok Ayukt Act. Examine the effectiveness. This is second part. तो पहले आपको लिखना है powers and functions of Lokpal and Lok Ayukt. लोकपाल होता है सेंटर में और लोक आयुक्त होते हैं स्टेट्स में। पहला लोकपाल कब बना था? 2019 में। यस, आप देखिए इसी से सेकंड पार्ट निकल आएगा, इफेक्टिवनेस। लोक आयुक्त फिर भी कई स्टेट्स में दे हैव इनिशिएटेड एक्शन अगेंस्ट द पब्लिक सर्वेंट्स इन देयर रिस्पेक्टिव स्टेट्स, पर लोकपाल ने 19 से लेके और आज तक आप बताइए एक भी केस है क्या? सो यू कैन, योर आंसर इज वेरी क्लियर. Lokpal has not been that much effective as it should have been. However, Lok Ayukts in certain states have exercised their authority and have initiated actions against certain public servants. बनाए किस लिए गए थे? जो कंप्लेंट्स आती हैं करप्शन पे, उनको इन्वेस्टिगेट करवा के उनके ऊपर एक्शन लिया जाए। ठीक है, लेट्स सी दिस। Allegations of corruption against certain public functionaries, उनके साथ जो रिलेटेड मैटर है वो भी, प्रॉम्प्ट एंड फेयर इन्वेस्टिगेशन। अब इसमें एक चीज आप और ऐड कर सकते हैं कि लोकपाल और लोक आयुक्त डू नॉट हैव देयर इन्वेस्टिगेटिंग एजेंसीज. They have to take help from either CBI, Central Bureau of Investigation, or from the State Anti-Corruption Bureau, State Police. That is one area which is affecting their effectiveness. कि कंप्लेंट आई, उन्होंने भेज दी इन्वेस्टिगेशन के लिए, उसका कोई जवाब नहीं आया, कोई एक्शन नहीं हुआ उसमें। और कंप्लेंट्स आती हैं इन लार्ज नंबर्स, so that also affects their functioning. National Anti-Corruption Ombudsman to look into complaints for the state, may make a law to establish an office of Lok Ayukt. Right? So, Justice Pinaki Chandra Ghosh was the first chairman of the Lokpal. Now we come to question number 4C, which happens to be the last question in section A of paper 1. Let's see this again. 15 marks, 200 words. If at any time it appears to the President that a critical question of law and fact has arisen, the President can obtain the opinion of the Supreme Court. एकदम से आपके दिमाग में क्या आएगा इसको पढ़ते ही? Presidential reference to the Supreme Court under Article 143 एकदम से आता है. And we have many number of cases in reference, started from Berubari case. You remember?
Yes.
Yeah. So there are so many cases like that. So it is when the President has a critical question of law and fact, there is a fact, and how to apply that law. That can be done only by way of interpretation by the judiciary. And that's why there is a constitutional provision under which President can refer such a matter to the Supreme Court for their opinion. Now comes discuss the role of Supreme Court. ये तो President ने भेज दिया वहाँ पे. अब discuss the role of Supreme Court in this matter by giving suitable examples. अब Supreme Court ने जो opinion दिया, what is the status of that? Is it binding on the President? Answer is no. But is it binding on other courts?
Yes.
Because what? It is quoted as a case law. Even today when we go to the court about the boundaries and this thing, secession of territory, we refer to N Berubari case. There are many such cases. Even judges' appointment cases, there is a reference from the President. But it is not binding on the authority that is President of India to go by that opinion. It's just an opinion for him. But for others, like legal professionals, courts, we use them as case laws. To put forward our point, again, it is open to the courts. There are various judgments on that. The courts, what view they will take on that. Anyway, let's see. It is expedient to obtain its opinion, the Supreme Court's opinion. The only conditions, what are the conditions? It's not that every case will be referred, everything will be referred. That he should be satisfied that the question of law or fact has arisen or is likely to arise. Second, that he should also be satisfied that such a question is of such a nature and such public importance that it is necessary, it is expedient to obtain the opinion of the court. Now, this is one case. The court cannot go beyond the reference and discuss other issues. Court cannot. It is only that matter which is referred by the President. The court can give its opinion only on that, not on any other peripheral issue, on any other issue other than that. Right? In Special Courts Bill, the question referred whether the Special Courts Bill or any is enacted would be constitutionally invalid. Kaveri Disputes Tribunal case. Advisory opinion is only entitled to due respect and normally it should be followed. Normally it should be, but strictly speaking, advisory opinion of the Supreme Court under this article is not binding on the President, though the President normally honors it. It's not mandatory. It's not binding on him. Is it clear? Can you write the answer in 200 words? Exactly the same thing. You don't have to write anything else. जैसा यहाँ लिखा है कि कोर्ट इधर उधर कोई चीज नहीं देखेगा, सिर्फ वही चीज देखेगा. यहाँ भी आप सिर्फ वही देखेंगे जो एग्जामिनर ने आपसे पूछा है. कोई फालतू की चीज नहीं लिखनी है. राइट?
इसमें एडवाइस के लिए कोर्ट बाउंड नहीं है, कोर्ट ना भी बोल सकता है.
ना भी बोल सकते हैं, बिल्कुल बोल सकते हैं. या so friends, with this we complete the section A of paper 1, all the questions, and you all know we have already studied all these in our sessions during your course with us, and also in our exhaustive notes in that comprehensive book on constitutional and administrative law, which is already available. Any other questions, doubts? In the next session, we'll take up the section B of paper 1. So we have divided this into 4 parts. Section A and B, 2 parts of paper 1. Similarly, section A and B of paper 2 also. All the questions will be discussed and all your queries will be answered. Right. Thank you very much.